All right, why don't we get started? Our next panel is a whistleblower update panel, which should be really interesting. First of all, shout out to Russell Capone, who was going to be here last minute. He could not attend, but I hope you're able to watch, Russell. So let me first introduce Jaime Marinaro, Senior Counsel in the SEC's Division of Enforcement in Fort Worth. She previously served as Vice President in the Regulatory Relations Group at Morgan Stanley, and also spent 6 years in the U.S. Army Judge Advocate General's Corp. Welcome, Jaime.
Thank you.
David Peavler, right to my left, is a partner in Jones Day in Dallas. He served for over 17 years at the SEC, most recently as Regional Director of the SEC's Fort Worth office and Associate Director for Enforcement. Welcome, David. Very pleased to be joined today by Douglas Paul. He's a partner at Akerman in Washington, D.C., and he's a former branch chief in the SEC's Division of Enforcement. He also previously served as an assistant independent counsel prosecuting public corruption. Welcome, Doug. And finally, very pleased to welcome Nicole Wells, our moderator. She's a senior managing director at FTI Consulting in Chicago and has 20 years of professional experience in providing consulting and expert services in forensic accounting and other complex investigations. Nicole?
Great, thank you. Well, good morning, everyone. As we all know, whistleblower activity is evolving with historic awards and continued changes to the program. We are very fortunate today to have a great trio here with us. They each bring an expertise both from the private practice and the SEC, so really excited to get into it. So let's start it off. I think first, kind of just to set the table, let's talk about the recent trends that we're seeing amongst whistleblower activity and SEC enforcement. So, Doug, from the private practice viewpoint, generally, what are we seeing by way of whistleblower activity and SEC enforcement from your vantage point?
From my perspective, what you're seeing is a lot more subpoenas that are coming to companies where you have to almost assume that there's a whistleblower involved. The SEC over time has gotten better at sort of disguising that in their subpoenas because they broaden out the number of people that they ask for in certain groups for their emails, things like that. But every now and then you'll see in there they'll ask for very specific items and you're like, there's no way they would know to ask for that type of journal or transaction or chronology without somebody having walked them through that in the beginning. The other thing is you're seeing, at least in the last 2 years, and I don't know if it was COVID related or whatever, from sort of a greater use of the internal hotlines for whistleblowing. I must have had a half a dozen corporate clients, partners who called me up and said, we got another whistleblower complaining about the use of the private jets. Can you do a review? Let us know what's going on. Do we have a problem? What do we need to know? And then I also said, you have to assume too that that same person probably went to the SEC because that's the way they get the protections under the case law. So we're just seeing a lot more activity in both of those areas. You also see larger and larger rewards that are going out. I think, assuming not much has changed recently, the reward of I think it's $297 million in May, that's, equal to, I think, every other year in aggregate, but for 2021. So you're seeing that. So the SEC is generally incentivizing individuals to report to them and not just use the hotlines, while companies would like the individuals to just use the hotlines.
Great. And just a quick question, in terms of that increased whistleblower activity on the hotlines outside of the private jets, is there a common sort of trend of claims that you see are being made in your experience?
I've seen a lot more in the financial fraud area that the companies are being aggressive in their accounting, the way they're looking at things. That has come up much more often in the last year or so.
All right, David, let's turn it over to you. How are these overall trends specifically impacting the numbers or types of claims and awards from your knowledge that you're seeing and that you've seen?
Yeah, I think what I would say is that the combination of the protections, the rules, the whole reporting process that the SEC has set up and Congress has set up with the bounties is working exactly like they wanted it to. It is encouraging an incredible increase in the number of complaints that the SEC is fielding, and then by the same token, the amount of fines and penalties that are resulting from whistleblower allegations have gone on a ramp. And if you look, you just see a hockey stick over the last 3 years or so. The $279 million whistleblower award is certainly the headline. It's the largest by far. I think 2.5 times the next highest. And what that is, the message that is sending is you need to be bringing your complaints to the SEC. It's creating a tension, I think, between what companies want and what the SEC may prefer. But it is working the way that the SEC wants. And I think it's even got to a point, and the SEC, when it issues or makes a decision on a whistleblower award, it actually puts an order out there. And you can go look at the order. They're heavily redacted. It's hard to read exactly what the case relates to. But you can see generally, sort of, the kinds of conduct, the kinds of things that the SEC deems worthy of awards. And one of the trends that I think we've seen is they're getting so many. Every time they put out one of these big settlements or penalty and disgorgement awards, there are all number of people who make a claim for those. And the SEC is actually this year is rejecting about 2 out of every 3 of the complaints or claims that it's getting. So that's what I think that is signaling is people are really paying attention to the SEC's whistleblower program. It's not a secret. Maybe a decade ago or right when it was getting started, it was a little bit of a secret and it was known amongst practitioners. Now I think it's fairly common knowledge. And as you see whistleblower awards where 7, 8, 9-digit awards are commonplace, I think it's only going to continue. Each year we're going to be pushing to set a new record in terms of whistleblower bounties.
Great, and you mentioned some of the activity around rejections around those claims and awards as well. And I think we even talked about how the circuit courts are now involved in some affirmation of that activity. I think the 11th Circuit just recently affirmed the SEC's denial of a whistleblower award. Maybe you can speak to that briefly.
Yeah, so I think one of the criticisms of the whistleblower program is that it's pretty opaque. It's really hard to know what is the SEC deciding, what factors does it consider when it's going to either grant or deny a whistleblower award. But because these awards have gotten so large, people are now going to federal circuit courts and appealing a denial. And so we're actually getting some visibility we didn't get before. And a really great example is that $279 million one. You really didn't know what case it was until the unsuccessful claimants went to the DC Circuit, and now we know it's the Erickson case. But you can see in those circuit court decisions, they are giving tremendous amount of credence to the SEC, giving it tremendous leeway to decide whether or not to grant these whistleblower awards or to deny them. And essentially is deferring pretty heavily to the SEC's decision-making in that area.
Yeah, thank you. Now to the SEC. So Jaime, what can you tell us from the SEC's viewpoint on the observed trends, the volume and types of claims, and the awards that Doug and David have just spoken to?
Yeah, sure. Let me start with our standard disclaimer. Everything I say today represents my own views, not necessarily those of the commission or the individual commissioners. I do have some numbers because I thought that they were particularly relevant, but in fiscal year of 2022, there were 12,300 whistleblower tips, and that is a very large number to be reviewed by the SEC enforcement staff. With that being said, for fiscal year 2022, there were 103 awards that resulted in $229 million in awards being paid out, which, as my co-panelist noted, is less than the most recent large award that was recently given. I think that what we've started to notice is an increase in tips related to market manipulation and then cryptocurrencies. There's a large amount of awards that, or I'm sorry, a large amount of tips that are coming in related to the crypto space, which, as we've seen with the uptick in crypto enforcement actions, may be interrelated. And I think with regards to the opacity of some of these awards, I think the Commission has tried to do a better job with that, coming out saying that all awards that result in a maximum award of less than $5 million are going to be a 30% value of the penalty that was awarded against the company. So there's tried to be a little more feedback to those involved to understand what those tips will look like. The maximum aggregate award issued was, or I'm sorry, the maximum aggregate award that was issued in particular cases, that maximum aggregate award was in 90% of the cases that were ultimately decided.
Yeah, no, that's significant changes, and certainly no surprise, I think, to anybody in the audience on the uptick with respect to crypto. Let's turn now to just briefly a discussion about some of the amendments to the program that have occurred over the last year or so. Jaime, do you want to just kind of give us an overview of those amendments and kind of their impact on changes going forward?
Yeah, of course. So, I mean, the SEC's goal is obviously to incentivize whistleblowers coming forward, and there's been an expansion of allowing the SEC to pay whistleblowers for non-SEC actions or related actions brought by other entities. There's also been an ability for the SEC to bar whistleblowers from bringing actions if they're kind of filing frivolous awards with the SEC, which is really designed to cut down on the amount of work the SEC staff needs to do in reviewing these frivolous tips. And really, there's become an internal process for reviewing the awards. We have a group called the Claims Review Staff. They review the whistleblower awards, and they make a preliminary determination. And when that determination is presented up to the Commission has the ability to vote on that. But the review of that is being done more internally at the SEC instead of going through the courts.
That's great. Well, and I think we had also...
One thing, if I could just jump in, because one of the changes, we're talking about some of the changes to the program, and I think you saw the move from the last administration to this administration. There was a change to give the Commission more bottom-end authority. In other words, if there was a huge penalty disgorgement, covered amount, the SEC wanted the ability to pay less than 10%. And I don't know why exactly, just there was a desire, I guess, to have more flexibility, not to give somebody a lottery, kind of a lottery win. But the new Commission came in and changed that and set a hard floor of 10%. And I do wonder, as we saw record penalties last year, and I wouldn't be shocked to see another record of some sort this year. Is the Commission going to regret that at some point? In other words, when they pay out somebody, $1 billion or some really large amount to one claimant, is that going to get people's attention in a negative way? I mean, I throw that more as just a question, but I do think that's one of the changes that's pretty significant, and it, like you said, signals how much the SEC wants to encourage whistleblowers.
And maybe, David or Jaime, if you want to speak to also the expansion of the program to allow the SEC to pay whistleblower awards for non-SEC actions or related actions brought by other entities, in which case, where those awards might otherwise be paid. For example, I think maybe we had talked about maybe the IRS or some others. Is that, that is also a somewhat recent change? Is that something we're seeing having impact?
I think it does, and I think it fits to the way that the SEC, putting my old SEC hat on, views it, is that there is a concerted cross-agency effort on a lot of these cases. And you see it particularly in things like FCPA violations or very large-scale accounting frauds, that the SEC may not be the only agency there, and the whistleblowers' information may have led to all of these different agencies moving forward. And so I think it was a recognition that it didn't seem entirely fair to say, well, the SEC maybe pulled its punches because DOJ is getting a very large amount or something like that. And so now, it will take into account a much broader scope of recovery for purposes of assessing, the whistleblower award.
Right, and we've seen those coming up where the orders look at the related action. So it's not just the penalty that was received in the SEC action, but maybe a counter DOJ action, IRS action, and they're aggregating the amounts in order to determine the award, which is resulting in overall higher award amounts.
Yeah, that's great. That's great. Okay, well, let's turn to the fun topic of retaliation cases. Always learning moments. So I think as many of us in the audience know, there have been some recent ones of interest. We're going to touch upon a couple today, and including maybe some that reach a little into the SOX world as well. So maybe, Doug, can you highlight for us some recent cases in which the SEC has taken action against employees who have either discriminated against its employees or otherwise attempted to stop its employees from speaking to enforcement agencies?
Well, first, as we were discussing before we came out here, it's shocking to me that it's September of 23 and the first sort of retaliation and impeding cases were in 2014 and 2015. The fact that companies don't get it today yet is still so surprising to me. And I know that in handling cases where it's either an internal whistleblower, someone doing something to the internal hotline, or you believe it's a SEC whistleblower, I think that every company that I've represented where there is someone like that, I feel like their natural first inclination is to say, who is it? How do we find out who the whistleblower is? And you say immediately, don't do that. It's dumb. It's only going to get you in trouble. And you're really not moving forward. So, one of the recent ones I think was the Gaia case, if I say it correctly, where, they got the complaint, they investigated it, they found no issue here, which, as David and I were talking before, turned out to be wrong. And then they decided for some reason that, okay, we spent all this money investigating it, now let's go after the whistleblower and let's concoct a story about why they were fired. And the SEC brought a case against the company for retaliation in that instance. Then recently, since this morning, I already had to change the most recent sort of impeding case, which was CBRE was just announced, and that came out. And again, it's one of these where it's the separation agreements, right, where you have to certify as the employee that I have not or will not report anything to an agency, including the SEC. I mean, to me, it's just lunacy that still exists. I mean, you had variations of that in like the Guggenheim Securities, where it is you can't collect the penalty if you were the whistleblower. The fact that this is still going on, to me, personally, I then put my SEC hat on, I'd be like, no wonder they get so mad at these companies, right? It's like, we have said this loud, we have said it, multiple times every year that this isn't appropriate. but for whatever reasons, companies aren't getting it.
Well, and I think with Guggenheim too, right? It was part that their annual compliance training actually included language that prohibited, employees from initiating contact with regulators. So, I mean, to the point of like, how is this still a thing? How's it going into compliance trainings is a bit
and
perplexing.
so every time we get one of these, I send it to, our corporate partners or our labor and employment partners, and I say, hey, you might want to just check this out. I know you probably have, but you probably have a new client you haven't done this for before, but it's just shocking.
Yeah. So one good key takeaway for everyone to bring back to their clients is a friendly reminder of what not to do. David, in addition to the 21F cases that Doug touched on, we know there's an active matter involving the question as to whether under Sarbanes-Oxley, a whistleblower must prove his or her employer acted with retaliatory intent, or whether the lack of retaliatory intent is part of an affirmative defense that, is on the employer to prove. So I think, we're talking here about the Murray versus UBS Securities case. Maybe you can kind of give us an update there and where it currently stands.
Sure, and to be 100% clear, this is a claim under Sarbanes-Oxley's whistleblower provision, which a lot of people now forget about, but Sarbanes-Oxley actually had a whistleblower provision. It wasn't terribly successful in accomplishing what Congress wanted, so they beefed it up and gave us the Dodd-Frank version. But the issue here that's pending before the U.S. Supreme Court is whether the whistleblower has to prove causation. In other words, that their whistleblowing was the cause of their termination or discrimination or whatever the problem is, and who bears that burden of proof. It's kind of more of an intellectual exercise at this point. I don't know how many Sarbanes-Oxley whistleblower complaints there are versus Dodd-Frank whistleblower complaints. Certainly our focus today is really on the Dodd-Frank side, but it is interesting because it will be one of the earliest times that the Supreme Court has spoken, or I guess the first time they've spoken since the last time when they said that you have to be a whistleblower under Dodd-Frank, you've got to report to the SEC. So we may get a little insight of how this current court thinks about whistleblowers and the whistleblower protection laws.
Great. So now we kind of laid the foundation, talked about the trends, awards, claims, and amendments and cases. Let's now get into sort of the best practices and the meat, if you will. So looking for the panelists' expert advice, David and Doug, we'll start with you. What should a company do when made aware of an internal whistleblower?
I think, take it seriously. Don't think that it is just somebody who's disgruntled or unhappy. Take it seriously. Look into the allegations. Do a investigation that is credible, that really tries to figure out if there is something wrong here. But also remember in the back of your mind the whole time, they may have blown the whistle internally, but they probably also are saying the same thing to the SEC, so that when you go before the staff, they may know as much, if not more, than you do going into it. I mean, as we all know, there's a cottage industry now of whistleblower counsel, who are guiding them through it, who are telling them what to do. So, your client's credibility and your credibility is on the line when you go in for that first meeting and you make definitive statements about what did and didn't happen when you may or may not know what did or didn't happen.
I think one of the first things that I try to counsel companies on is when you are made aware of a whistleblower complaint, percolates through your complaint system, it comes up through a supervisor, whatever way it comes up, there's some really almost simple things you can do that seem to work pretty well. The first of those is to acknowledge to the whistleblower that you've heard them. Acknowledge that their complaint, even if it seems frivolous or far-fetched to you, is something you take seriously. It's going to be handled and treated with the right level of seniority and the right level of urgency. And not letting the whistleblower necessarily control your actions or dictate what you do, but letting them know this is important to us. Because I can tell you from the SEC staff side, they are going to take it very significantly. They're going to treat it kind of, one of the default reactions I think I've seen with some companies is, we don't believe the whistleblower. Whistleblower is wrong. It's just like the automatic knee-jerk reaction. The SEC staff, on the other hand, have the exact opposite knee-jerk reaction, that the whistleblower is credible, the whistleblower has information, and we're going to pursue it. And so you have to understand that as a, if you're advising your client, that that's what the SEC is going to come into it with. And so you need to be treating that whistleblower with the right level of respect, and hear their information. And I've seen it even in the relatively brief time that I've been out in the world. Sitting down and listening, letting somebody tell you their story, and acknowledging what they are saying goes a long way towards them wanting to continue to cooperate and not immediately shutting down. And then then they are going for sure over to the SEC.
And sort of building off of what David was saying about taking them seriously, hearing their story, investigating it, there's also an upside sometimes to the company. Even if that person isn't exactly right, it's how you can improve your processes, your policies and procedures on certain issues, because this person has seen a problem or what they perceive to be a problem, and sometimes there's an easy fix to that. Sometimes there is a problem. But if, like David said, you take it seriously and there are changes that come out of that, you go a long way to hopefully getting rid of repeat whistleblowers, of others who are seeing similar type things, taking it seriously, and maybe even the upside of whistleblowers who say, I just want to help the company. I'm not here for the big bounty, but I'm here because I like this company, I want them to do the right thing, and it's a way to encourage sort of compliance and things like that.
And if that whistleblower who maybe is reporting internally but has not yet come to the SEC, say that person is wrong. If you do an investigation and you make them feel heard and you've looked into this issue and you ultimately decide that there wasn't anything wrong here, that may prevent that person from taking that allegation to the commission, who is then going to investigate it, and you're going to spend a lot of resources responding to commission subpoenas. And maybe all that person wanted to do was be heard. And I mean, the flip side, that is a legitimate investigation. You've now taken it seriously, you've investigated it. So when the SEC staff comes knocking on your door with a subpoena or a call to counsel, you can show that you've taken this seriously, you've looked into the allegations, and that you're going to cooperate with the investigation.
So one of the first whistleblower cases I had when I left the commission really hit on something that Jaime said, which was the company did the exact opposite. They didn't take it seriously. They investigated it internally. They concluded there was no merits to it. Lo and behold, the person went to the SEC and complained, and what might have been something that could have been contained turned into, a 2-year investigation, just a whole host of unintended consequences of not taking it seriously, not hearing them. So it was, again, there's that unintended benefits and consequences of not listening to people.
Example number one of what not to do. I'm sure we have many more. Now, David, if you get a call from a client and it's an internal whistleblower, came through a hotline, in-house has decided, and with your advice, it's significant enough to warrant an internal investigation. Are you advising your clients kind of to operate under the assumption that that whistleblower has already gone to the SEC?
I think you have to now. I don't know if 5 or 10 years ago you would have necessarily had that assumption, but I think you have to now, in part because, like I mentioned, the bounties that are out there and well publicized, and the cottage industry of law firms who do this kind of work representing whistleblowers, there's going to be plenty, all somebody has to do is get on the internet and type whistleblower, and they're going to hit 50 law firms saying we'll take your whistleblower case and you'll make lots of money. So you have to assume that, and I think but and what does that mean though? So they've gone in. Does that mean you should act differently? If your reaction normally would be to do what the Gaia company did, which is to fire the person for raising these complaints, then yes, you should not do that. You should react differently from that. But if, beyond that, you should be taking it seriously, proceeding with your investigation, remembering, one of the backdrops, which we haven't even touched on, is the incentives that the SEC and the Department of Justice have placed on self-reporting and bringing things, open swiftly to them. Having a culture, having a compliance culture that encourages internal whistleblowing is almost the only way you can expect to meet what DOJ and the SEC want on self-reporting. And so when you become aware of that, you should assume that there's this clock ticking over here with the SEC while they're assigning it and reviewing it and talking to the whistleblower and getting information. That's your time to start doing your own work and getting your arms around this problem, so that if you say, hey, there is something credible here that we need to go and at least alert the government to, we would have that fighting chance of getting that cooperation credit. That is pretty valuable.
Yeah.
One of the factors the SEC does consider in determining whistleblower awards is the amount of assistance given to the staff. So when you have a whistleblower coming in, handing you emails and documents and telling you how to craft your subpoenas and whose testimony you should take and who to reach out to, and they've put a lot of time into analyzing maybe publicly available data and piecing your case together. If I have someone coming in handing me a case that's pretty open and shut, that whistleblower is going to get a lot more credit. So to the extent a company is aware of a whistleblower kind of early on when this person may just now be reporting to the commission, I think it's really helpful, as David mentioned, for cooperation credit, that you get there fast and you lay it all out and you're honest and here's what we found in an internal investigation before we've kind of had time to dig through these very detailed whistleblower notes and work that they've put together in order to help us with our investigations.
And we've had related where we're not quite as far as Jaime says, but you can see where it's going already. You can see that this is a problem, whether it's in sort of the FCPA area, things like that. You know where it's going to head to. And to what David said is you got to get the cooperation. DOJ may be a little more clear about what cooperation means compared to the SEC, but you need to get in there, because more times that I've heard the staff say, well, it took you a long time to get in here, or you waited till it was tied up in a bow before you came to us, or we had a whistleblower who already told us that at some point down the road. You start falling further and further behind in order to get the credit, whether that is a lower penalty, something like that, or things like that. So you have to sort of balance that, like the need of the client not to go in too early versus when it might too late to go in. And, it's a little bit of a tea leaf reading as you're trying to make that decision. But, if you get in there early and you're also clear and transparent with the government about what you know now, and that could change some as you learn more.
Yeah, and Jaime, you referenced good examples and expectations of the SEC from a company. Give us some examples of poor behavior, poor results, in addition to what Doug has referenced.
Yeah, I think Doug's talked about it a little bit, but when you come in and you say things to the SEC that they know are untrue. You make statements about complete investigations that have been done, finding that the company didn't do anything wrong, or interviews you've done and we find out your investigation wasn't complete, or you make statements that I know based on documents of yours that I've seen are completely untrue. I think that you lose a lot of credibility with the staff, and when you have counsel come in and want to do proffers and try to have some cooperation later down the line, you've already killed that element of trust with regards to counsel. And to Doug's point about trying to lessen penalties through cooperation, even trying to eliminate penalties. There have been a number of cases where there have been $0 penalties based on the amount of cooperation credit. I think a couple of them, there was a June 20th case of 23, Stanley Black & Decker, July 3rd, View Inc. There are 0 penalties issued in these cases, which I can't say whether or not a whistleblower was involved in any of these cases, but if there was a whistleblower involved in these cases, that whistleblower would not be entitled to any award based on the amount of cooperation credit given to each of the companies.
And I think further to Jaime's point, which is like the Headspin case, I don't know if there wasn't a whistleblower where there was no penalty, but where the director went out of his way to show other things beyond cooperation, beyond turning over documents, beyond proffers, beyond that, of corporate reforms that took place. Mm-hmm. So there is other type of cooperation outside of what we normally think of during the course of the investigation that can be done. Again, you don't know how they'll view it, but sometimes doing good corporate governance may get you that piece of cooperation that you may not have gotten otherwise.
Yeah, I think we could probably do a full day on cooperation credit and what it is and isn't, but I think the whistleblower, the way I look at whistleblowers is they have become the most important source of information for the SEC Enforcement Division, period. Mm-hmm. The biggest cases, the most significant, most challenging cases are almost all coming from whistleblowers. And I know, and I'm looking around the room at former SEC people, we all know how hard we tried when we were on staff to get whistleblower complaints into our office, because those let you start a case, at second base instead of, having to try to, start from home plate. And that makes a difference. So the SEC probably knows something about your case by the time you're walking it in. And I think that means you need to be prepared to be objective, to be credible. Not to say you can't advocate or you can't say, well, we don't think this or we think that. I think that's important. You can still do that. But I think where I saw companies really stumble is when they would come in and we had a whistleblower and we had information, and then the company comes in and they hand us a lot of things that corroborate the whistleblower's complaints, but then they would reach some advocative point of, but we still didn't see anything that violates the law. And it's kind of like there's a dissonance there. And for the staff, it's like, okay, well, thank you for that. We're now going to have to go about our business and go through this full investigation. So I think what whistleblowers have done is made it harder to make that advocacy piece that you might have been able to do 10 or 15 years ago. And I think we all have to recognize that.
And whistleblower counsel have just gotten really good and really effective. I mean, like all lawyers, I wouldn't say everybody's effective, but there are very effective ones out there. And they come in with documents, and I've spent time with whistleblower counsel, and they've helped me craft document requests. They've told me what to look for. They've told me where to look, whose computers to look on, whose email to search, titles of certain spreadsheets or documents to specifically ask for. So I think, when you're looking at subpoenas, and it's also a point we were talking about earlier, how do you hide the identity of a whistleblower when you're sending a document request where you're asking, you want this one spreadsheet that's got a name where, the company's going to receive it and they're going to go, they very clearly have a whistleblower. And now we actually know who it is, because the only person who would have done that is, person X. A lot of times we will kind of expand on the subpoenas and ask for all spreadsheets, under this topic or
Including
something
but not limited to this one.
Not limited to the one where you get maybe a smaller category of documents, but you are trying to hide the fact that we do have a whistleblower because it's our duty to hide the identity of that person. But my point, just you have these counsel who spend time on calls with us, walking us through, and it's very important for the staff and for whistleblower counsels and whistleblowers to make notations of what documents they're providing and the calls they're having and what information that's being provided to the staff, because the staff then does use that to put together the recommendation for how much of an award that whistleblower will get in the event that they are entitled to an award.
Yeah, and Doug, David, I think we talked about this briefly when we were prepping as well, but we started this off by talking about in the event your client calls with an internal whistleblower through a hotline. What if your client just gets a straight up preservation notice or subpoena from the SEC? Is there any different advice, or is it anything different about your advice and approach besides obviously telling them they need to up their compliance and reporting?
I think from my perspective, the advice and the approach is very similar. But with the caveat to the company is it's fair to suspect that there's a whistleblower because of the nature of the preservation notice or the nature of the request. Especially, if it's something that really isn't public, right? There was no public filing announcing some problem or a restatement. I mean, these are sophisticated investigations that you're getting on corruption or on, where I see it a lot is in the accounting fraud area, because they're just asking for things that somebody would know. And sort of to Jaime's point, they're doing it broad enough that, it's no longer the give me everything all of your accounting records from the beginning of time. It's give me them related to A, B, and C, where they may only be interested in B. But the way it's being done, I think the advice is the same. Do not spend your time hunting for the whistleblower. And if you do find out who the person is, like David said, listen to them, ask them the questions, make sure they're being heard, but also being very cautious that you don't want them to misinterpret any of that as you're retaliating against them. So it's sort of that double-edged sword.
And I think that's, that circumstance you're talking about I've seen it from the government side where, there's a whistleblower, case starts, the investigation starts, company in the course of doing document production or interviewing witnesses says, we kind of figured out who it was. And I think that can be a really tough spot for a company to be in, because what do you do with that person? Do they just keep on keeping on? Do you cut off their access to information? Do you reassign them? There are a lot of decisions that can be very hard. And then I think it could be doubly or triply hard if the employee, if that person is not a great employee, maybe is subject to some other kind of performance discipline or some other. And so you get in these really challenging situations once you've figured out who the whistleblower is. And I think I can't give you, okay, this is how you do it, the cookbook for it. Every case has to be, looked at very carefully. Documentation of if you are going to discipline the person is absolutely critical. I'm not a labor and employment lawyer, but that seems to make a lot of sense, because the SEC has looked at circumstances where a whistleblower is removed from their access or is reassigned to a different job or not allowed to go to conferences that they have traditionally gone to, and consider that to be retaliation. And so for companies that do discover that, it is a little bit of a tightrope that that thankfully that's what we get paid to do, I guess, is to try to guide them over that tightrope.
And also sometimes when the SEC has the whistleblower, you suspect. I mean, the subpoena doesn't come with a header or a watermark saying whistleblower on it. You also sometimes, in building the relationship with the SEC, knowing what's important to them, what they're prioritizing, how they want things. A lot of that, and clients don't always get that understanding that having these conversations with the government is important and may help them in the long run.
And in our final 20 seconds, maybe Jaime, key takeaway that you would want the audience to know from the SEC standpoint on whistleblower activity.
Yeah, I would say make sure you understand that whistleblowers have probably already come to us. So at the point you have information about corporate wrongdoing or potential wrongdoing, when you come to us, be open, be transparent, be honest, or don't say anything.
All right, thank you. Thank you very much.